5 seconds to go. Start. These issues have already been dealt with in Vijay Madan Lal. Suffice it to say that Section 50 enables the authorized authority to issue summon to any person whose attendance he considers necessary for giving evidence or to produce any records during the course of the proceedings under the Act, and that the persons so summoned is bound to attend in person or through authorized agent and to state truth upon the subject concerning which he is being examined or is expected to make statement and produce documents as may be required by virtue of subsection 3 of section 50. At the stage of issue of summons, the person cannot claim protection under Article 23 of the Constitution, the same being not testimonial compulsion. At the stage of recording of statement of a person for the purpose of inquiring into the relevant facts in connection with the property being proceeds of crime is not an investigation for prosecution as such. The summons can be issued even to witnesses in the inquiry so conducted by the authorized officers. The consequences of Article 23 of the Constitution or Section 25 of the Evidence Act may come into play only if the involvement of such person noticee is revealed and his or her statements is recorded after a formal arrest by the ED official. In our opinion, the learned counsels for the appellants have sought to re-agitate the issues which have already been settled in Vijay Madan Lal. Much reliance has been placed by the learned counsels for the appellants on the annual report of Ministry of Finance GOI, which according to them had stated about the organizational structure of Directorate of Enforcement, demarcating the territorial jurisdiction of various zonal offices of the ED. According to them, such instructions by the Department of Revenue are for exercise of powers of investigation by the ED as mandated by Section 51 PMLA and therefore must be strictly complied with. The said submission, also being fallacious, cannot be accepted. Apart from the fact that the document relied upon is an annual report by the Ministry of Finance showing the organizational structure of the ED, the same could not be construed as the directions issued by the central government for the purpose of exercise of powers and performance of the functions by the authorities as contemplated in Section 51 of the said Act. As stated in the said report, the said offices of the Directorate of Enforcement all over India are set up to ensure that the money laundering offences are investigated in an effective manner and they act as deterrents for the potential offenders of the money launderers. Pertinently, the Headquarters Investigation Unit HIU has not been restricted to any territorial jurisdiction in the said organizational structure. The present ECIR is recorded at the HIU. Further, as per the specific case of the ED in the complaint filed against the accused persons before the Special Court PMLA Delhi. Stop.